Mr Chairman, the reality about the Government Communications Security Bureau and related legislation amendment bill is that its name is totally misleading, because this is not some sort of benign and innocuous reconfirmation of an existing piece of legislation, or for that matter an affirmation of an existing organisation in its current form. This legislation makes radical change to the GCSB as we presently know it, and to the powers that it will be allowed to exercise. And so, Mr Chairman, the name of this bill is very important. What we call it will be very important, and it is very important because of what we know, because the way that this debate has been conducted, not so much in this House but in other forums around New Zealand, has been to mislead many New Zealanders about the reality of what is happening. The truth about it is this, is that the way the bill is drafted gives extraordinary extensions to the powers of the GCSB, not the least of which is its definition, or its change of a definition from computer system, which is the language presently used, which is what the area in which the GCSB is statutorily mandated to operate, changes it from computer system to information infrastructure. And the definition of information infrastructure is as wide as you could possibly imagine. So it includes electromagnetic emissions. It includes communication systems and networks, entire networks. It includes what is described as information technology systems and networks, and any communications carried on, contained in, or relating to those emissions, systems or networks. There could not be a more comprehensive definition of the way that information and communications are carried and conveyed in New Zealand today. That sets the scope for what the GCSB is now going to be allowed to do. So to say, or to give the impression in its title that this bill is simply about reaffirming or tidying up what the GCSB presently does is just totally misleading. And on that basis, the GCSB is given power to intervene and to intrude and to invade the privacy and the protections that every citizen would ordinarily expect and is entitled to expect when it comes to communicating and storing information digitally about themselves. And this is one of the critical things about the way this debate has been conducted. And it's not just peculiar to this legislation, but it is certainly peculiar to this government, that basic citizens, civil or human rights that we have enjoyed, that are confirmed in legislation that we've got, that are confirmed in international agreements, are continually put up as now conditional on some other agenda or objective that this government has. That it's no longer enough to claim an inherent right to privacy. That's now dependent on something else that this government might put up, an economic or corporate condition that might be overlaid with it. And so, sir, this is the insidious thing about this piece of legislation. We are entitled to a basic right of privacy. We do have a right to be free from unreasonable search and seizure, which this bill compromises. We do have a right to freedom of expression. Those rights aren't dependent on anything else. They stand on their own. And we are entitled to claim those, and we are entitled to have those rights protected. And this bill fails to do that. And so the name of this bill and the impression that has been given from the outset and throughout has been misleading. So the scope of this bill is now extended to intruding on New Zealand citizens. It was originally confined, and all the drafting of the present Act makes it very clear it was confined to foreign intelligence and intelligence on foreign citizens. And now this makes the giant leap and gives the power and the scope to the GCSB to now intrude upon the privacy and the protections of every New Zealand citizen. The safeguards that we would ordinarily expect in a piece of legislation like this are non-existent. There's an attempt at providing safeguards, but the exclusions and the exceptions make them a nullity, make them nugatory. And Section 14 is the classic. There's a loophole there in the protection against interception into New Zealand citizens' communications and digital information. And that's not good enough. It goes on to say that anything that is incidentally obtained by the GCSB is not to be considered as having been obtained unlawfully. That is the major encroachment.
No, the member needs to seek a call if he wants another one.
Mr. Chairman.
I probably inferred that it's Andrew Little, so I'll give him the call. Andrew Little.
Thank you, Mr. Chairman. I apologise for I was thrown by the bell, which it was happenstance, as we've discovered earlier today. Mr. Chairman, without wanting to accord any undue levity to this piece of legislation, because this is a grave matter, and we've seen that despite every effort by this government to reduce its significance, to minimise it to the citizens of New Zealand, the reality is that citizens have woken up to just the insidious powers contained in this bill. And one of those aspects is that it goes on to say that even though there is a sort of a defined scope of the information that the GCSB can secure and the level of interception they can indulge in, there is a proviso that says that anything obtained outside those powers is not to be regarded as having been obtained unlawfully. Well, that's no protection at all. And that's like all of the so-called safeguards in this legislation. There are exceptions to it that mean that they mean absolutely nothing at all. And that is what is so frightening to those who have looked closely at the legislation, those who don't sit inside this House, but those institutions and organisations on whom this House routinely relies to provide independent scrutiny of legislation and give advice to us. And the Intelligence and Security Committee heard from submitters, not the least of which was the New Zealand Law Society. And let me be very clear about that. The original submission from the New Zealand Law Society was drafted by probably one of New Zealand's preeminent human rights lawyers, Dr. Rodney Harrison, QC. In fact, not just one of, probably the preeminent New Zealand human rights lawyer.
He got his QC for good reason too.
And he got his QC because he did what most QCs are required to do, and that is to take difficult, unpopular cases and argue them through the full hierarchy of the courts, and he did very well. But he was very clear about the extraordinary encroachment on citizens' rights that this bill represents. Then, when the Prime Minister introduced his supplementary order paper, it wasn't Dr. Rodney Harrison QC who commented on that, it was another QC, Austin Forbes QC, a former president of the Law Society, a very man of great eminence in the legal community and in the New Zealand community generally, and he said the SOP that the Prime Minister put up provides no further safeguard than was what there before. And he reiterated and confirmed what the Law Society had said, is that nothing less than a full inquiry into the need and the rationale for the changes to this bill and an investigation into its impacts was required. And that was a point taken separately and independently of the Law Society by the Human Rights Commission and by the Privacy Commissioner as well. Statutory bodies who we look to give advice to us about the legislation that is passing through this House. And it is wrong for their advice to be treated as dismissively and as derisively as it has been by this Prime Minister and this government. So this is a very sad day for New Zealand, and this week will be a very sad week for this House as we pass this legislation in contempt of those with great authority and wisdom who are telling us it is not the right thing to do. No one is arguing against the need for good security agencies, well-supported and well-resourced security agencies. But when we take a step in this House and pass legislation that intrudes extraordinarily on the rights, the basic rights and protections that every citizen in this country is entitled to have and to have upheld by this House and the enforcement agencies of government, then that is a step that we should take very, very cautiously and very, very carefully. And we should take it with full knowledge and understanding of the impact that we are taking. We don't have that luxury with this piece of legislation because it has been rushed through, pushed through, bulldozed through by a government that is no longer listening to the people of this country. And the people are concerned, and they're right to be concerned, because whatever way you read this bill, this piece of legislation, it simply is cause for great fright and fear. And so, Mr. Chairman, this legislation shouldn't be named the GCSB and Related Legislation Amendment Bill. It should be the Unfettered State Security Agency Bill, or it might be called the GCSB extraordinary powers bill, because that is what it is. And that is why New Zealand citizens are concerned, and not a single member of government has stood to defend it today, and that is even more outrageous in this important and very sensitive piece of legislation that every citizen is entitled to look to every member of government to and say, how do you defend this bill?
Nikki Wagner.
I move that the question be now put.
Chris Farfoy.
Chair, for the chance to speak to the